Family Violence Intervention Order hearings. What to expect. In this video, we'll explain the different types of court hearings you might have for a family violence intervention order. It's a good idea to get legal advice before your court hearing. You can call Legal Help, Victoria Legal Aid's free helpline on 1300 792 387. Message us using Legal Help Chat or find a community legal centre near you. You might be able to meet with a duty lawyer on the day of your hearing. See our video on getting free help from a lawyer at court to learn more. If you have questions about court or are worried about your safety there, you can contact the court you're going to. You should also fill out a pre-court information form on the Magistrates Court website to tell them about yourself and what support you need at court. There are 4 types of hearings for a family violence intervention order. Every case is different, so you might only have one or you may have a few. An ex parte or interim hearing happens if the person applying for protection, the applicant, asks the court for an urgent, temporary intervention order. This is called an interim order. The person accused of family violence, the respondent, does not go to this hearing. A mention hearing is the first main hearing. This is to see if both sides can agree on what they want to happen with the intervention order. If a lawyer is helping you, they might speak to the other side or their lawyer. The police will also help if they made the application. The court's aim is to come to a safe agreement. The magistrate might ask you questions to help them decide what will happen next. They might also make an interim order on this day. If there is no agreement and the magistrate does not make a final decision about the intervention order, you might need to come back for a directions hearing. This is where the magistrate works out what's needed for a final hearing, including any witnesses who need to attend and whether you have a lawyer. Sometimes you can come to an agreement at the directions hearing and the magistrate will make a final order then. This means you don't need to come back for a final hearing. A final hearing is where you give evidence or tell the magistrate what happened. The other side, police or witnesses might also give evidence. A lawyer will cross-examine you, which means they will ask you questions to confirm what you have said. If the magistrate agrees that family violence has occurred and is likely to continue, they will make a final intervention order. A final family violence intervention order is a legal document that says the conditions or rules that must be followed and how long the order will last. Here are a few things to remember about going to court for a family violence intervention order. It's a good idea to get legal advice as soon as possible. There are different types of hearings and you might have more than one. The magistrate will make a decision based on what they think is safest. There are opportunities along the way to try to resolve the matter. For free legal information about going to court for a family violence intervention order, contact Victoria Legal Aid or a community legal centre. You can also contact the court you are going to find out what services they have to support you. There are many support services you can speak to. Remember, help is available.